proceed with the matters. Some objections have been raised. We don't think that those objections really have any merit. The allegations or the assertions are only going to delay the process from moving forward. What we would like to do is to get started as quickly as possible and to get to the end of the process as quickly as possible. We would like the trials to take place in the magistrates' court. The magistrates are equally able to handle what it needs to be done. The norm of the practice and the procedure is that you would usually, matters that are triable either ways, are usually disposed of summarily because of it can be done fairly, reasonably in these courts. In terms of the allegation or what allegation is made about whether I'm an MP and whether I can be a prosecutor, there are 5 other prosecutors. The risk that is being complained of is really nothing to do with the reality of what is going on. The arguments about bias doesn't relate to a prosecutor. Bias relates to the tribunal that is hearing the proceedings. It is not uncommon in many criminal proceedings, that are private criminal proceedings, that the family of the deceased or the family of the virtual complainant would hire an attorney at law to prosecute on their behalf. That's the process. If you were to eliminate that, then how would you ever achieve that? The test of bias, the test for the appearance of bias, and the test for whether it would be fair or not is really relates to the tribunal. As long as the tribunal is independent, whatever duties that have to be performed by prosecutors are not being performed by me alone. There are 6 persons who, as a group, have been given a fiat by the director to go ahead with. The entire issue is a red herring. It's a 33 is not half of 65. Because what you're doing is you're conflating 2 things. You're conflating the obligations of a prosecutor with the test of bias. The test of bias relates to the court and the tribunal, not to the prosecutor. All right? Good.